Welcome everyone to our webinar on IP for in-house lawyers, protecting your organisation's assets. My name is Rebecca Jones and I'm the practice group leader in LegalVision's trademarks team. I'm joined today by my co-host Corinne Whelan, who is the practice group leader in LegalVision's franchising team.
Hi.
Before we begin, a couple of quick housekeeping items. You will receive the recording and slides for this webinar in your email. Please submit your questions in the Q&A box and we'll answer them at the end. And please complete the feedback survey after the webinar. You are eligible for a free consultation with LegalVision to learn how we can help your in-house team manage your high-volume, business-as-usual legal tasks. To access this offer, please provide your contact details in the survey at the end of the webinar. So today we'll be discussing what you need to know about protecting your organisation's IP assets as an in-house lawyer. In the first part of the webinar, Corinne will discuss the most important things for in-house lawyers to know generally about IP protection, including managing your IP protection within your corporate group, with employees and contractors, and in third-party contracts. She'll also give you some guidance on implementing internal IP guides and policies, on auditing rights when supplying IP to others, and things to bear in mind about IP and website interactions. In the second part of the webinar, I'll go into more detail about trademarks and branding, often one of an organisation's most valuable IP assets and one that we've received many queries about, a lot of which I hope will be covered for you within this webinar. I'll go into some tips for protecting your organisation's brand, some pitfalls to avoid, and what you need to know about maintaining and enforcing your trademark rights. At the end of the webinar, we'll answer some of your questions, so please feel free to submit them throughout the webinar, and thanks very much to those that have submitted questions ahead of time. And now Corinne will speak about IP protection within the corporate group.
Thanks, Rebecca. Hi, everyone. So just to kick us off, I wanted to speak at a high level in regard to, I guess, the foundational intellectual property of a company, just as a bit of a refresher over some of the fundamentals that we like to think about. From my experience, businesses with in-house lawyers tend to be larger organizations. They often have multiple entities within their corporate group. So while it may seem basic, it is important as an in-house lawyer to keep track of each entity's role in your ultimate corporate group and how all of those entities relate to each other and use and exchange all of the IP. In-house teams should ensure that the foundations of their group's IP ownership is tight from the outset. There's a few practical ways that you can do so, and at a high level, I usually think about doing the following. First of all, you should ensure your agreements are prepared between all entities within your corporate group so that the flow of intellectual property rights and the control of each of those rights is clearly clarified with each entity within the corporate group so that it's clear on what entity is using what IP and what rights are provided within the contractual documentation itself. At a minimum, IP license and assignment documents should be in place to show the use of IP between entities in a corporate group. So if necessary, it may be worthwhile having a separate IP holding entity for each arm of your business in order to keep everything separate within its own mini kind of corporate group. If you haven't already, ensure that there is a holding company or an IP entity set up, and this ideally would be done in the earlier stages or phases of a company's, growth. This is so that you avoid, other tax implications of moving IP later on. Having an IP holdco basically will help you protect all of those assets and hold all the IP within that one entity, which prevents other entities from potentially, and external parties potentially claiming that IP later and clawing at it in case of disputes or litigation. If you do have a corporate group established, make sure that all of the operations and other entities that are in that corporate group are assigning their intellectual property to the holding company or IP company. You should ensure that the holding company then provides those operating entities and other subsidiaries with a license to use that IP on a particular set of terms. It is also good to review these situations and these arrangements on a regular basis to make sure that what is documented in the paperwork is what is happening in practice within that corporate group. Something that people often don't think about as well, or forget when we're creating companies and ready to just go and want to start operating, is think about the role that each director plays in those businesses. And you should be thinking about the fact that those directors of entities should be assigned or should have assigned their IP up to the IP holdco, um, just so that it is sitting with the relevant entity and not sitting with those individual directors or founders of the company. I often find this coming up during the due diligence process when, somebody's looking to invest or somebody's looking to maybe sell off an arm of the business. One of the things that people look at is, did all the directors validly assign their IP up to the entity that's relevant at the right time? And you should also check that any registrable forms of intellectual property are registered in the name of the correct entity. I know that this is basic, but it's something that often goes overlooked. For example, do you have all the trademarks held with the right entity who is using those trademarks? Once you have unpacked your IP within the corporate group, it's important to turn your mind to how you practically protect the intellectual property of the business as your business expands and brings more people into the business. Some ways you can do this is by ensuring that all employment contracts have relevant and fair restraints and confidentiality clauses. Bearing in mind that restraint laws vary from state to state within Australia, so be sure to check the state of employment or create templates that align with the general provisions across the relevant state that you're operating in. If you're engaging contractors, we recommend you have your own form of agreement, which deems that any goods or services provided during the course of their, contracting to you is deemed your your IP. It's really important because this clarifies positions on whose IP is whose. It avoids any misunderstandings for later on down the piece when things have gone too far. In particular, you also want to be thinking about, does your contractor agreement adequately determine and just speak about things like background intellectual property, for example, what you're bringing to the party, what they're bringing to the party. Think about what's going to be developed or improved as part of the intellectual property and make sure it's clear on who owns everything at the end of the project. For in-house teams, I find contract reviews and negotiations can often be where intellectual property should be considered, but is sometimes forgotten when you have other competing interests at the same time. For example, when you're given a deadline by the marketing team for an upcoming sponsorship, you have to do a deal with a new supplier or manufacturer, or you're tendering for the provision of goods or services. So often when we're thinking about all of those things, we're thinking about liabilities, we're thinking about indemnities, sometimes the IP piece is actually forgotten about. We're not really focusing on it. So I've just created some better ways to be prepared and what I recommend you do to be prepared for those contract reviews. Firstly, you should ensure that all pre-contractual discussions, regardless of what type of contract it is, are being done after a non-disclosure agreement or confidentiality agreement is signed by both parties. This obviously keeps everything discussed confidential and ensures that anything you share throughout that contract negotiation process is going to be protected through a non-disclosure agreement. Have your legal team review and negotiate any unfavorable intellectual property clauses. It's very common for third parties to have standard IP ownership rights over their works without contemplating how commercially pragmatic that is or whether it's something that the other side might be interested in. As such, I recommend being prepared for contracts to be one-sided and likely unfair when it comes to IP ownership, and ensure that those particular clauses are adequately reviewed by your in-house team. Something that we also recommend is creating a contract review framework for your in-house teams to use across all contracts, but especially for any explicitly involving IP use. Use these to determine what the IP rights are and your positions ahead of time. For example, are you agreeing to an exclusive or non-exclusive use of your IP? Do you know where the IP can be used? For example, is it going to be used across Australia? Is it going to be used in New Zealand? Is it going to be used in a specific state or territory? Think about whether the intellectual property will be sub-licensable, whether the party that's getting the use and the benefit is allowed to sub-license that use or benefit to somebody else. Make sure that in your review process, it is a preventative process rather than responsive. What I mean by that is having a system in place for what the business's position is in regard to intellectual property ahead of time, rather than dealing with IP issues and IP ownership rights as they arise. And don't be afraid to amend and vary the intellectual property definition or any annexures within the contracts you do negotiate and prepare to capture relevant changes to the intellectual property or scope throughout the term of the contract. This provides certainty around the use of the IP and the ultimate purpose of the relationship. Where public perception of your brand is of utmost importance, consider implementing guides for your marketing or PR teams and employees, which direct people in the business on how to refer to the business. This is super important for big brands who require constant review of their marketing collateral and or the public persona of the business itself. Some examples and ways to do this include creating a guide for how to refer to your company, its brand name versus maybe its entity name. That includes how to refer to the company in publications, in ads, or in other marketing collateral. You may want alignment with the marks you have registered. If there is an abbreviation of your organization's name, then determine when this can and cannot be used. I find some clients, end up in a situation where they've got one name that is in the public domain, but that might not be something that they've registered and protected, and they might want to veer away from people referring to that business as, colloquially as they've originally intended. So having these internal guides are very helpful. I recommend that legal works with your marketing team to create clear legal brand guidelines to ensure alignment between businesses' assets and legal protection, including the approved logos, approved color schemes, approved statements that should be made to the public, alongside all of the other materials that will be public facing. I also recommend you create internal policies on what can and cannot be done with your intellectual property suite. For example, is your legal team giving a framework to marketing, which ensures that only approved trademarks are used in publications? Is there a certain shortened name for the business which you do not want used in publications? All of that should be considered in your internal IP guides. When entering into other contracts with other parties, it's important to ensure that you have auditing rights, which obviously must be fair and reasonable, particularly given recent reforms in unfair contract terms. But it's something that I see often being forgotten about. So companies often enter into contracts where the use of their IP is not controlled adequately, which puts at risk, disputes over the use and ownership of those assets and that intellectual property. I recommend you include certain obligations on third parties, like audit and reporting back to you. This allows you to inspect the materials and use of your IP, request changes to it, and determine other issues which need to be addressed throughout the use of your intellectual property. Auditing the materials or services or statements that are using your IP will help you control the use of that intellectual property, and also ensures that the dollar value that you're being paid is actually attributable to what you should be getting. For example, some people will audit how many goods are put out using their trademark, and based on that they may determine a dollar value in exchange for the intellectual property. So constantly be mindful of all of those things. So, and with online presence obviously being crucial to the development of a brand, it's often important to consider the use of your intellectual property on the internet. Again, I recommend that as an in-house lawyer, the legal team works with the business and marketing teams to establish positions on how the business will use the IP within its online presence. There are a few ways you can control this and get better protections in place. The main ones are ensuring your domains are monitored and renewed. So keep a catalog of and database of all of your domains and the renewal dates. Keep track of other domains that may be similar, or buy domains that may be used to compete with your branding. Consider the same for social media pages, especially pages which may have reputational damage on the brand if they're created as a slight variation in order to try and compete with what your brand is. Where you are running social media campaigns or using influencers, be mindful of what your terms and conditions say, including who is representing the brand and the contracts signed with any talent. For any websites you do have, just ensure that adequate terms of use are created, which explain where the IP sits, and make sure that those terms are explicit on the information and data ownership, particularly that that data and information on your website cannot be scraped or used for an alternative purpose. I often find that most policies and terms of use on people's websites are the ones that their web developers put in when they initially created the website. So having like those terms and conditions actually reviewed and properly drafted within your legal team really help to protect you and that IP that will be available on your website. If possible, have all entrants to your website click accept on the website terms so that you can enforce these rights if needed. So to summarize that, obviously these are just a few specific ways that in-house teams can work with other areas of a business to protect your company's intellectual property. We'll answer some more specific questions about generalist IP experience, but for now, I'm going to hand it to Rebecca, who is going to talk all about trademarks.
Thank you. All right, so first off, excuse me, for in-house lawyers, it is crucial to have an understanding of the trademark protection framework in Australia. So trademarks can be either registered or unregistered in Australia. Registering a trademark is done by applying to IP Australia, which is the government department that administers IP rights. Registered trademarks are protected under the Trademarks Act 1995. Provisions within the Act give registered trademark owners the exclusive right to use the trademark or to authorise others to use the trademark in respect of the goods and services for which it's registered. It also allows a registered owner to take action for trademark infringement. Unregistered trademarks, on the other hand, are not recognised or protected under the Act, but you may still be able to take action for unauthorised use of an unregistered trademark under the misleading and deceptive conduct provisions of the Australian consumer law or under the common law tort of passing off. Now, although it's possible to enforce both registered and unregistered trademarks, there are significant benefits of registration. So, first of all, a registered trademark is generally easier to enforce. Establishing trademark infringement involves assessing the unauthorised use against the particulars of the trademark registration. So you'd be looking at, are the trademarks substantially identical or deceptively similar? And are the goods or services provided the same or similar to those covered by the registration? On the other hand, if you're relying on misleading and deceptive conduct or passing off to take action against unauthorised use, rather than relying on a registered trademark, you first need to establish that the relevant reputation in the trademark exists. Now, that obviously comes with a higher evidentiary burden, which, more evidence, more effort, and more expense. A registered trademark also gives broader geographic protection. So this generally extends to all states and territories throughout Australia, whereas recognition of reputation and rights in an unregistered trademark may be limited to the specific geographic area where the trademark has been used or where the business is operating. This can significantly reduce the scope of protection and the enforceability against other traders. IP Australia's public register of trademarks also serves as a good deterrent. So if other parties are looking at adopting a new trademark, they can clearly see your rights in the trademark listed on the public database, which can serve to warn them to select an alternative trademark. And finally, later filed applications for similar trademarks will be blocked by your registration. So IP Australia will generally refuse to accept a similar trademark if someone applies to register a trademark that is similar to your existing registered trademark in respect of similar goods and services. It is possible to rely on unregistered rights to oppose an application once it has been accepted, but having your trademark on the register means that that new application will likely be blocked automatically by IP Australia rather than you needing to take active steps to oppose it. And lastly, and this might seem simple, but it's so important, to ensure that the business and in particular the marketing team are aware of and using the correct symbols alongside the branding. So the trademark symbol can be used, or the TM symbol can be used as soon as you start using a trademark, whether you've applied to register it or not. And the R symbol, on the other hand, can only be used once the trademark has been successfully registered. Now let's look at some practical steps for in-house lawyers. Say your marketing team comes to you with a proposed new brand or sub-brand asking if they are clear to use it. The first thing you want to do is conduct some clearance searches. So you can use IP Australia's database to search for trademark applications or registrations for similar trademarks that cover the same or similar goods or services that you're looking to provide. This gives you a very quick indication of whether the proposed branding would put the business at risk of an action for trademark infringement. You'll also want to carry out some marketplace searches for potentially unregistered trademark rights that could still be used to challenge the use or registration of the new trademark. If that all looks clear and you're pushing ahead with the branding, then I'd recommend getting your trademark application filed as soon as possible. Filing the application secures your priority date, which is essentially a place in the queue, and it will then block later filed applications. Now, in terms of the scope of protection of a trademark, there's quite a few things to think about here. So when you're applying to register a trademark, you list the goods and services intended to be provided under it. Goods and services for IP Australia's purposes are classified into 45 different classes. You've got 1 to 34, which are goods, and then classes 35 to 45 are services. Now, it's super important to get the scope of protection right. I like to think of a trademark registration as both a shield and a sword. So from a shield perspective, it protects the organization's use of the trademark. So you want to make sure that the use falls within the scope of the registration, i.e. that the registration is broad enough to protect the use. It also enables enforcement against third parties. So this is where the sword aspect comes in. So again, you want to ensure that the registration is broad enough that you can take action against any unauthorized use that might pop up in your space. Since the protection and enforceability of the registered trademark is defined by the specification, it's really important to get it right. Now, you might wonder, why can't we just register it for all goods and services and that way nobody can use it at all? So you need to have a genuine intention to use the trademark on the goods and services covered by the application, or it might become vulnerable to removal or opposition. Use of a trademark doesn't have to commence immediately, and trademark registrations don't become vulnerable to removal for lack of use until 3 years from the registration. So when you're filing an application, this means that you can think ahead a bit and incorporate the business's future expansion plans into the scope of your protection. Now, in terms of the different types of trademarks that can be registered, the most common would be logos, words, slogans or taglines, and icons. It's also possible to obtain protection for non-traditional trademarks. They're relatively less common and can be more difficult to secure. But some examples of these are, it is possible to register a color as a trademark, for example, Cadbury's color purple for chocolate products, or a sound trademark, for example, Nokia's distinctive ringtone. I just wanted to note as well, if the business has overseas expansion plans, it's important to remember that trademark rights exist on a country by country basis. And again, you can think ahead with your plans here when it comes to international protection and get the ball rolling early. Particularly in first to file countries such as China, or those with long examination delays such as Canada, where it's taking, at the moment, I think it's over 2 years to reach the examination phase for a trademark application. You want to get the ball rolling in those jurisdictions as soon as possible. And lastly, I just wanted to note that if you are filing internationally within 6 months of your Australian application, you can take advantage of the 6-month priority date, which means you can backdate your international application to claim the earlier priority date of your Australian protection. All right, now let's look at some practical tips. First of all, what makes a good trademark? Perhaps the most important one is a trademark that is available. So you want to make sure that it's not similar to other existing trademarks to avoid the risk of legal issues. You also want to choose something that's distinctive. So the best trademarks are unique and memorable and capable of distinguishing your business's goods and services from those of other traders in the marketplace. You really want it to be able to stand out and be easily recognizable by consumers. You also want a trademark that is not generic. So using common terms as your trademark make it difficult to obtain exclusive rights and therefore difficult to enforce. So essentially, if you adopt a less than distinctive trademark, you'll need to tolerate other parties coming a lot closer to your branding in terms of using similar common elements. The manner of use of the trademark is also important. So you want to ensure that the trademark is used as it is registered to ensure that the use is protected. You want to avoid descriptive or generic use of the trademark, because if it becomes the generic name for that particular product, then exclusive rights in that trademark can be lost. So ideally, you would use a descriptor after the brand where possible. For example, if your brand was escalator, you'd be best off using escalator moving staircase. Escalator is just one example of what was once a registered trademark, but those rights were lost when the term became generic in the marketplace. As the brand evolves, amendments or variations to your branding should be registered. So this includes new logos, sub-brands, and taglines or slogans that might be used from time to time. It also includes changes to the scope of protection. So if the product team are working on a new offering, you'll want to review the existing protection to see whether it's covered within the scope of that existing registration or whether another application needs to be filed to expand the scope to cover that new offering. You want to ensure the correct symbols are used to identify registered and unregistered trademarks, like I touched on earlier. And as Corinne mentioned earlier as well, create guidelines for the stakeholders that are using the business's branding and carry out regular audits to ensure compliance and to identify any gaps in protection. Now, one of the really common things we see are trademark ownership issues. It's really important to get ownership right. A trademark application or registration can be challenged before IP Australia on the grounds that the applicant is not the true owner of the trademark or is not intending to use the trademark or to authorize the use of the trademark. It is vital that applications are filed in the correct owner name, particularly in cases where there are multiple entities within the corporate group. If the owner and the entity using the trademark are separate, for example, in the case of a holdco and opco scenario, ensure appropriate licensing structure is put in place to avoid inadvertently eroding the trademark rights. You'll also want to be really mindful of managing potential infringement risks. Ideally, trademarks should be registered before they are used for the business, but practically understand that this is not always possible, given it takes 7 to 8 months from filing to achieve registration, and obviously things often move a lot faster than that. At a minimum, I would recommend carrying out clearance searching before using a new brand or sub-brand to reduce the risk of inadvertently infringing a third-party right. Now, trademark maintenance, I'll just cover off a few brief tips here. Make sure the business maintains a detailed record of its IP portfolio. So records should be kept accurate and current and readily available when they're needed, rather than trying to scramble to get the details together when an issue arises. Also, stay across your relevant renewal deadlines to keep all of the IP up to date, valid, and enforceable. You want to make sure you don't inadvertently allow anything to lapse due to the deadlines not being noted appropriately and the records not being kept up to date. You can also use this as an opportunity to carry out reviews to determine which rights are still required and which might no longer be useful or valuable to the business. All of these can kind of help with budgeting for IP maintenance as well. So you can avoid unnecessary refiling or renewals and avoid late payments during grace periods, which usually increases official fees. Now, you'll also want to be aware of the use requirements for trademarks. So in Australia, trademarks become vulnerable to removal from the register if they have not been used for 3 years. If you have a trademark that is entering that period, has not been used, but the business still intends to use the trademark in the future, you could consider refiling it to essentially restart the clock on that use requirement. This is also another reason why the manner of use is important, because a registration needs to be used as registered to be protected from removal for non-use. Also remember that IP protection is generally not set and forget. You'll want to update the portfolio as the business evolves. So carry out audits to identify gaps in the protection, and also in your day-to-day activities, always kind of keep IP protection at the back of your mind. Are there any new logos that the business is using? Are there new product categories being developed? And make sure that everything is protected and you're on the front foot with that. And finally, a few pointers on enforcement. So I would suggest regularly monitoring third-party trademark applications. You can do that via IP Australia's database with a view to opposing them if necessary. Keep an eye on the relevant market for competitor activities and potential misuse of your brand. And a good tip to do this is to set up Google alerts as well. So if anyone is making use of your brand, it will land in your inbox for you to review. If you do become aware of any unauthorized use, take swift action to stop it. If you allow it to go unchallenged, it can cause damage to your brand and it can be much more difficult to address later. And back to you, Corinne.
Thanks so much, Rebecca. That actually concludes the main part of our webinar. However, you might find our publication Guide to Protecting Your Brand useful. I think that is available on the next slide. Yes, there we go. So you can have a look at that link there and use a QR code. Otherwise, we can also send you a copy of it. You might also be interested in our upcoming event, The Power of Branding, Building and Protecting Your Brand with IP Australia. So that will be on Wednesday, 23 October at 6 p.m. Now, we're going to answer your questions shortly. While you submit them, please feel free to start sending them through. We have some pre-submitted questions that we'll get to shortly. But while you submit them, we'll take a minute to tell you about LegalVision's desk extension. So having spoken to hundreds of C-suite and in-house counsel, we understand in-house lawyers are increasingly being pulled in many directions. They're required to provide input on business critical and strategic matters at an executive level, whilst also managing a high volume of business as usual matters. And of course, all managed within a tight budget and even tighter labour market. Under a desk extension, LegalVision can assist you with all of your business as usual legal needs, allowing you to cost effectively increase the bench depth and capability of your team and to prioritize those business critical matters. Our desk extension lawyers invest upfront in understanding what's important to your business and work as an extension of your in-house legal function. To learn more about how desk extension can help you and to help provide your detail, to help you, you can actually provide your details when the survey appears at the end of this webinar, and we'll reach out to you and help you. So now we are going to answer some of your questions. If you haven't already submitted them, please start submitting them. Otherwise, I'm going to address one that we had come in prior. One of the questions was, how do I protect intellectual property that isn't registrable, but forms a large part of the intellectual property and the intellectual capital of the business? For example, things like tools, methodologies, recipes. This is a really good question. And the way that there's a few ways you can do that. Most of those ways speak to kind of what I've already spoken about. But the first thing is, check the contracts that you're entering into. Obviously, those types of methodologies, tools, things like that are confidential information that are confidential to your business, but it can't be protected by being registered. So the best way that you protect those items of intellectual property is within your business practices themselves, ensuring that your employees are signing adequate employment contracts which say that everything they create and everything that they come into exposure of whilst they're involved and employed by your business is going to be owned by the business. It's really, really critical because obviously when you're employing people or you're bringing on board contractors, they're obviously going to have access to a lot of confidential information. So it's very, very important that you have adequate protections within the contracts you are providing to those employees or those contractors, any third parties, that adequately protect you and the IP and those confidential trade secrets and things like that. Certain tools and things are protected under the Copyright Act, but if we're talking more generally about, I guess, know-how, that's not necessarily something that is protected under copyright, and it's not something that you can register. So be mindful of that. A good example that I like to use when I'm talking practically about what this looks like is, we all know Pepsi and Coke and their confidential recipes on how to make their product. The reality is that only two people ever know that recipe, and those people obviously would have very tight restraints and very tight confidentiality obligations, but they have two people that know that information. So think about your business in that way. Are there certain people that maybe shouldn't have access to that information? Then that's another way of protecting it as well. Do you want to answer one of the next questions that's come through, Beck?
Yes, we received a really good question that's come through live.
Okay.
You mentioned utilizing an IP holding company in the case of a corporate group. Wouldn't that make it vulnerable to removal for non-use? I'm unsure as to whether licensing of trademarks, for example, would constitute use with trademarks, for example, under Section 92 of the Trademarks Act. It's a really good question. So under the Trademarks Act, use that is authorized by the registered owner essentially gets attributed to the owner. So if the relevant control is made over the entity using the trademark, then that would protect it from removal for non-use, because any authorized use would be taken to be used by the owner. Where we see issues arise is when that use is not controlled sufficiently for the use to be attributable to the owner. So that's in terms of the control of that use, there's two aspects. One would be if the registered owner exercises financial control over the trading activities of the entity using the trademark in the case of a corporate group or a subsidiary. But the other one is when the registered owner is controlling the quality of the goods and services provided under the trademark. So that's why it's important to actually exercise the rights to audit and to control the use and the quality of the goods and services provided. Having a bare license agreement in place without actually exercising those rights is often where we see people get into trouble with ownership issues and potential non-use in the case of a holding company.
Yeah.
Did you have anything to add on that, Corinne?
No, I completely agree. It's exactly why I mentioned doing those auditing rights and making sure that you are properly keeping track of the use of the IP once it is being licensed. Completely agree. Like just having a standard form license agreement, but then not actually doing any of the audits or exercising those rights is where that risk is kind of more likely to arise. So have the contracts in place, but then also make sure you follow the processes in that contract as well around auditing and ensuring that you're comfortable with the use of those of that IP, and particularly the registered trademarks, so that they don't become something that you can't prove you're using. Great. I can take the next live question that's also come through that says, for entities part of a group under a parent entity, should there be an intercompany licensing arrangement between the owner and the subsidiary and the sibling companies? Yeah, absolutely. The easiest way that I would think about it is obviously if you have your group and you have your main hold co or IP co, then definitely have an agreement between that and the subsidiaries and sibling companies that are going to be using that IP and, probably creating goods or services through the use of that intellectual property and those marks. However, if there are also maybe further subsidiaries underneath those entities, I also recommend there's two main ways you can do that. You can add an additional license into the arrangement, which says, well, obviously, one entity licenses to the other, then that licensee also has the right to sub-license. And you would do that by either formalizing a further sub-license in an approved form by the ultimate owner of the IP. That's how you hold that control as well. Or you can do it through by saying they have a sub-license. The other way that some people do it is they will do a really big IP license and assignment document with every relevant entity in the group as part of that contract. It's not the most ideal situation because obviously entities come and go. There might be certain situations where you don't want to have all of that, set up in that particular way. So, recommend that you think about it on a case by case basis. Like maybe all of the entities that fall within the corporate group that have a similar business interest in mind. So maybe you have a services company and then you also have a products company. Maybe it's good to have those license agreements set out with their own rights in relation to the IP that's used for that particular purpose. Because when we're talking about intellectual property, I think it's also really important to think about what is the purpose of the use, and that should be put within those documents. And if the purpose isn't relevant to the whole of the group, then having specific relationships and contracts between those entities in that group for that purpose is a good way of doing it.
Excellent. I'll take
cool.
this next question that was submitted ahead of time.
Yeah.
What protections are available for an unregistered trademark being used without permission on social media? So I touched on this earlier in that registered trademark can be enforced by way of an action for misleading and deceptive conduct or passing off. It really depends on the conduct itself. Is the trademark being used as a trademark? Is it implying some sort of association with your business which does not exist and therefore is misleading or deceptive? Or are they using it in a way that is essentially passing off their goods or services as in for those of your business? So I would suggest, like I said, trademark registration is the easiest way to enforce because it's black and white. It's a lot easier in terms of establishing those rights, but worthwhile still sending a cease and desist letter potentially to someone making unauthorized use of an unregistered trademark to put them on notice of your kind of common law rights in the name, let them know about your concerns and ask for them to cease that conduct. That also raises another point as well in terms of online platforms. And this is another benefit of trademark registration as well, is that often these online platforms have IP protection policies in place where they facilitate and make it easier for the owners of IP to submit complaints and takedowns for unauthorized use of IP. Often they will require evidence of trademark registration to enable you to enroll within that. I'm thinking of, Amazon's brand registry enrollment. So that can be another benefit of registration as well.
Yeah, great. A live question that's just come through, and I just want to answer it before we start wrapping up because I am mindful of time. But a question that's been submitted is, what are the pitfalls of joint IP ownership? Again, very good question. Look, it is a difficult one because as soon as you start jointly owning IP, there is the debate and the question over how do you divide up that asset later when you go to sell it or when you need to deal with it in some way or another, including potentially even just giving its approval for its use with other third parties, because now you've got essentially two or three or multiple entities that have to agree to that use. So in my opinion, a joint IP ownership is a very difficult one, and it does create a lot of difficulty with trying to enforce rights, particularly while everything might be nice and happy days at the start of that joint IP ownership. I can't help but, see some of the issues that arise when IP is jointly owned, and the arguments over who contributed what and how we divide up that asset is a real big one. This is quite common with, in the SaaS, like any, software as a service, where you may have multiple people that have contributed to the code and the baseline of what has created, that software or an app. So having joint IP ownership makes it really messy when we come to later on selling, or when it comes to even due diligence that's undertaken on the company about how you justify that. Most of the time, in my experience, when you do have assets that are owned jointly, when you go to sell the company later, or you go to get investment and somebody undertakes due diligence on your company, they will want usually to see some kind of agreement in place that one of the parties will only be the owner to it. So as part of, their agreement to give you money, they will often say, well, we want to see that this jointly owned asset is actually moved over into your entity, or it's sold off and is now owned by the other party. So it is quite a complicated one. Yes, I think. What other questions do we want to? Did you want to answer any more questions, Rebecca, or we should probably be wrapping up?
Yeah, I don't think we have time for any more, but sorry for any that we didn't get to.
Yeah. If you have other questions, obviously feel free to reach out. We can have a consultation with you and help you out with everything. But unfortunately, that is all that we have time for today. And we're really sorry if we haven't been able to answer your question. Feel free to submit your details in the survey at the end for assistance with questions that we didn't answer, or to learn more about how our membership can help you and your business. And while this is a free webinar, we always value your feedback. So please feel free to complete the 30-second survey at the end so that we can get feedback on how we can make these webinars more enjoyable for you in the future. But otherwise, thank you so much for joining us.
Thank you.
Thanks.